Start. The rule, which is the most universal, namely that the best evidence the nature of the case will admit shall be produced, decides this objection. That rule only means that so long as the higher or superior evidence is within your possession or may be reached by you, you shall give no interfere proof in relation to it. Section 65 deals with the proof of the contents of the documents tendered in evidence. In order to enable a party to produce secondary evidence, it is necessary for the party to prove existence and execution of the document. Under Section 64, documents are to be provided by primary evidence. Section 65, however, permits secondary evidence to be given of the existence, condition or contents of documents under the circumstances mentioned. The conditions laid down in the said section must be fulfilled before secondary evidence can be admitted. Secondary evidence of the contents of a document cannot be admitted without non-production of the original being first announced for in such a manner as to bring it within one or other of the cases provided for in the section. Before I deal with the rival contentions of learned counsel for the parties, it, it would be appropriate to understand the basic idea behind the provisions of the Act relating to relevancy and evidentiary value of the documentary evidence in proving or disproving the claim. Since the power of documentary evidence in either proving or disproving a claim is undeniable, therefore, determination of a question of admissibility of document is crucial in any trial, for it can change the course of entire trial and consequently fate of parties. The Act entails elaborate provisions relating to admissibility of documents. The best evidence rule requires that if the contents of a writing are to be proved, the document must be proved. Some documents are self-authenticated, such as ancient document, recorded deeds, and other documents over 30 years old. However, other documents are required to be proved in accordance with the provisions of the Act. Needless to say that in cases where the document cannot be proved by primary evidence, secondary evidence to prove the same is permissible under the Act, while the photostat copy of a document which is accurate reflection of original document is accepted as secondary evidence, but it has to be shown that the photostat copy is authentic and accurate reproduction of the original.